come into this courtroom yet and given us any evidence that there is such a problem as Chad buildup when it comes to voting. So no matter what this witness said under cross-examination, it doesn't make a difference because there has been no evidence that there's such a problem. I'll tell you one other thing, Wolf. Spokesman for the court is telling us that the judge has been told that there are 2 more witnesses for the Bush team, and then they'll be done. Now, that doesn't mean they won't call more. They reserve the right to call. They had 95 witnesses on their list. They never were going to use that many, but they reserve the right, depending on how the case is going, to call more witnesses. But right now, a court spokesman says they believe they will only have 2 more. As far as when the decision would come down from the judge, it won't necessarily come right after this case has been heard. The judge could wait a day, write an opinion, but he could also sit on the bench and utter his opinion immediately. They just don't know at this point when that opinion will come down. But one thing we have to keep in mind, once the Bush team rests, then it's a chance for the Secretary of State's attorney to have his case. Each county can have a case, and there are interveners in this case, lawyers representing common citizens who have complaints, so it won't be over once the Bush team rests.
All right, Gary Tuckman in the courtroom, and as we look at a picture of the Gore legal team led by David Boies, we're going to take a quick break. When we come back, this hearing is expected to resume momentarily, and of course CNN will bring it to you live. Stay with us.
Okay, let's see if we got everyone. All right, then defendants will call the next witness.
Your Honor.
Sir?
Before we start, could
Yes.
I address the court?
Yes, sir.
When we started, Your Honor will recall that we pointed out the urgency that we felt we needed to have in reaching a conclusion on the issue of whether or not we recount these votes or count these votes. And I would like to suggest to the court that under the court's power that's under this statute, that the court has almost plenary power to conduct this proceeding as it chooses in order to reach an orderly and correct result that the court desires to reach. We are most anxious, Your Honor, if there are some matters that we might restrict. For example, if the court is going to rule that we can count, we would like the court to consider that as soon as possible, or if we're not going to count, the same thing. The other issues really bear on that from our presentation and standpoint. And I think, I don't know exactly how else to put this, but if we go another day or two, our remedies...
We're not going to go another day or two if there's any benefit.
I'm asking the court to consider that and do, if necessary, let us know where we stand. Thank you.
We need to proceed with the next witness, and
Your Honor, may I have one matter?
of course, with respect to any whether or not we're talking about the count that you just request, as my understanding of the law, that the court must first find as a fact that there's a legal basis for ordering any such recount before ordering it.
Once again, as the second session begins today, just after the lunch break, up to Washington and Greta Van Susteren. And Greta, another question from the Gore attorneys, Dexter Douglas, a question about time and if they can get any direction as to how much longer this will proceed.
Bill, it was just a strategic move. The reason why Dexter Douglas did this on behalf of the Gore campaign is he's creating a record in the event that the Gore campaign must rush to the Florida Supreme Court to get this judge to order a recount quickly. He wants to be able to say, look, Judge, we tried, to the Supreme Court, look, we tried to push this judge faster. Just creating a record. Lawyers do it all the time, and they have to do it.
And Greta, most folks will tell us down here in Tallahassee, and I'm sure you would agree, that whatever decision comes out of this court and whatever decision Judge Sauls makes, it will be appealed to the state's highest court here in Florida.
Lawyers don't give up, Bill, not often.
Back inside the courtroom, Phil Beck now.
Witnesses total
remaining here. We need to quit talking about it and move ahead then, it sounds like. Perhaps we'll have the case back to the plaintiff's side momentarily.
And Your Honor, the Secretary should be able to put her case in documents and not have any live witnesses.
Very good. Then we'll just consider our intervenors, and they only had one witness, I believe it was listed, or Mr. Butler did, and I don't know how many Mr. Myers. I think we're going to make some substantial progress here. I think we're breaking the dike.
Your Honor, Ron
Mr.
Sullivan, we have an emergency motion pending to intervene on behalf of 6 registered voters in Nassau County.
It's a little late at this point, sir. I can't take up any more motions to intervene, but you can certainly stay and watch, or to the extent that the interest of your clients coincide with the other intervening parties that are here, I'm sure they would be happy to benefit from any consultation or other information that you may have. All right, let's call the next witness.
First have your question. Dick Cheney called William Roloff.
Ask him to come forward and be sworn. We'll lose the clerk. Which clerk? Oh, all right. You want me to do it? You can hardly see you on that. Would you raise your hand? Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, sir. You may proceed.
Sir, would you please state your name and spell your last name for the record?
William John Roloff, R-O-H-L-O-F-F.
Where do you live, sir?
In Broward County, Florida.
What do you do for a living?
I'm a law enforcement officer.
How long have you been a law enforcement officer?
27 years.
Did you vote in the last presidential election?
Yes, I did.
Would you please tell the court what you did when you went into the voting booth?
First went in and signed in and received my ballot. I went over to a vacant voting machine, looked over the instructions. Up until that point, I still hadn't decided several issues on how I was going to vote. I placed my ballot into the slot. I started actually at the back of the ballot and started to place my votes. When I got to the presidential candidates, I was still undecided. And all the other votes that I had cast, I had taken the stylus and I had put it directly down the center of the hole like the instructions say, and pushed all the way down and removed it. When I got to the presidential candidates, I took the stylus. I was still undecided. I placed it over the name of one of the candidates, and I just decided that I didn't want to cast a vote.
Did you pull the stylus out then after you'd already touched the ballot with the stylus?
Yes, sir, I did.
Now, do you know one way or another whether you made a dimple on that candidate's name that you decided not to vote for?
I have no idea. I don't know how much pressure is needed to make a dimple or a scratch mark in it, but I didn't push the stylus all the way down through it.
Well, if you did make a dimple on that man's name, do you want that dimple to be counted as a vote for a man you decided not to vote for?
No, sir.
No more questions, Your Honor.
May I inquire?
Mr. Roloff, is it?
Yes, sir.
From Broward County, sir?
Yes, sir.
My name's Dino Kitchen. I don't think we've met. What you told us, I believe, Mr. Roloff, is that in all of the elections you intended to cast a vote, you punched right on through.
Yes, sir.
And on the presidential slot, you did not punch through.
That's correct.
At most, as best you tell, there may be what we call a dimple.
There may be, yes, sir.
So if your ballot was reviewed in a hand recount, you would see clean holes all over the place and one dimple.
Yes, sir.
Now, sir, you would agree that your fellow citizens in Broward County who went to the polls and intended to vote for President of these United States, you would agree that if there's any way reasonably practical that their vote can be counted as they intended it, that should be done, don't you?
Yes, sir.
And you're certainly not telling Judge Saltz that if he feels in order to get the true intent of your fellow Broward Countyans by reviewing some of these ballots to see if their intent could be discerned, you want him to do that, don't you?
Yes, sir, but I don't believe that, especially on my ballot, that anyone can interpret my intent when I only make a dimple mark.
But you know you got a dimple on one and all the rest have a clean hole.
Correct.
Think it might be reasonable to say, looking at yours, that dimple wasn't an intent to vote on your ballot.
On my ballot was not an intent. I had changed my mind.
And certainly you would agree that you would rely on the people this court chooses, if indeed it does, to make the decisions that need to be made under our law.
I would hope so, yes.
Thank you.
I had just one. Mr. Roloff, you mentioned you started at the back of the ballot. You all have a hot sheriff's race down there?
No, I believe it was uncontested.
Oh, it was? Oh, okay. Was there any reason that you start at the back of the ballot? Is that your practice, or?
No, it's just that going in, I knew I had still undecided on who to vote for the president.
So you decided
I figured I'd start at the back at the least important races, maybe, and work my way forward.
Well, let me ask you one more thing. Did you, after you pulled your ballot out, after you finished voting,